Hello, Realtors. Welcome to the Legal Podcast. I'm Byron King, lawyer here at South Carolina Association of Realtors. Tiara, introduce yourself, please.
Hi, I'm Tiara, one of the attorneys on the team and the Director of Fair Housing here at SCR.
And you can reach us at the legal hotline. That's 803-712-3478 or info@screaltors.org or Byron at screaltors.org or Austin at screaltors.org or T. Pitts at screaltors.org. Today we got a special guest star. We got Todd Beckstrom, ERA here in Columbia. Todd, if you can introduce yourself and talk about the NAR Professional Standards Committee 2022 and 2023 summaries.
Thanks, Byron. It's been my pleasure to serve at the local, state, and national level on professional standards for many, many years, and to be a part of changes to our Code of Ethics, which, as you know, is a living, breathing document, right? It changes every year. And it is what makes us who we are. It's the reason this organization exists. The Realtor organization. So Byron had asked me to come in. Actually, I'm going to be 2024 Professional Standards Vice Chair and then move to Chair in 2025. I'm really excited about that and hopefully making some positive changes to our Code of Ethics. So from 2022, these are changes that took place in January of 2023. So I wanted to go over those quickly. So we revised Article 10 and other parts of the Realtor Code of Ethics to take out the word handicapped and insert disability instead. We thought it was more appropriate language given the time, and we made that change. We also made a revision to Standard of Practice 3-9, and that's for realtors shall not provide access to listed properties on terms other than those established by the owner or the seller. In the past, it said the owner or the listing broker. And as we know, the listing broker does not own the listing and should not be able to grant access. And so we added the terms because a lot of times the owner is not the seller, right? There could be an estate, there could be somebody else representing that seller who's not the owner. So we made that change. We also, there was a lot of talk about what constitutes a real estate professional. And for purposes of Article 15 of the Code of Ethics, it's those who are engaged in the disciplines of real estate specified in Article 11 of the Code of Ethics, and you guys can find those there. So pretty easy. We wanted to make it consistent throughout the code. We also clarified that if you're prohibited from serving in more than one capacity in an ethics or arbitration matter, and that also applies to if you're an ombudsman, which I am, or a mediator. I could not sit on a hearing panel. I could not sit on a grievance committee. I could not sit on a board of directors that would be certifying that decision, if you will. Let's see. We also clarified that hearings cannot be heard anonymously, that any complaint referred to a hearing must include a complainant, so they get to face their accuser. If it's a member of the grievance committee, it could be that as well. And they basically shoulder the burden of proof, right, in a ethics hearing. We also, there's something called an expedited hearing process. The grievance committees now have latitude to determine if the conduct alleged in the complaint is sufficiently egregious enough, like a public trust issue, for example, to warrant a hearing rather than a waiver to a right of hearing. So we were having some situations where we had some pretty bad things coming, and they said, we'd just like to use the expedited, and we'll go ahead and be found guilty. But they were violations of the public trust, and we thought those have to go to a hearing now. And the grievance committee can make that decision as far as there. We also removed the board president from the process of receiving a copy of the ethics complaint. Those will now be carried out by the professional standards administrator. And also only realtor principals can invoke arbitration, and it has to be with another realtor principal. So as you know, the broker in charge, principal broker, can invoke arbitration and has to be against another principal broker. It can't be agent versus agent. So we clarified that. If there's a non-realtor principal, they are not required to arbitrate. So it's important to note as well. We amended policy statement 45, which is you have the right to, as an association or a board to publish the name of Code of Ethics violators and the citation policy. If you've taken that choice and you want to do that, and you voted that that's going to be your policy, then the rules have to be adopted by the association. And we made some minor amendments to modernize 24 case interpretations found online, just to kind of clean it up. So those were the 22 changes that went into place in 23. We're now almost to December. We're holiday time now. We just got back from the NAR next convention in Anaheim, and we made some changes there as well, which were voted on by the board of directors. And one important one that was not sent forward that you'll see in the future, I'll go ahead and cover it as well. So the first one was, it says that mediation shall be offered when a complaint comes in. And actually we changed that to may be offered when a complaint comes in. It does not have to be. Some people want it to go through, some associations want it to go through the grievance process. So you may offer it up front or you may offer it after the grievance, right? So two different ways. We talked about access to properties earlier. You cannot misrepresent as a listing agent the availability of a property to show, and perhaps let your friend or broker show their buyer the property when it's being held out for other people. We made some changes to the chair guides, which I think those of you who are chairing hearings are going to like. One is pronouns. We changed he and she, him and her to they, them, and their, okay? Instead of ladies and gentlemen, it's changed now to panel members and hearing participants. All right, that was a great change as well. Board or boards is changed to association or associations. And some people still call themselves the board, right? So in that case, they can still use that terminology. It doesn't have to be. You can't talk about offers that were made during mediation during an arbitration hearing and say, well, you offered me this during then. You can't bring that up anymore. So as the chair, you're going to be responsible for saying, hey, that can't be brought up. And then a lot of times we use alternate panel members and they're sitting on the panel in case something happens, or maybe we're trying to bring somebody along and get them seasoned for their first hearing. As you know, they can't go into executive session, they can't comment, they can't ask questions. But we thought it would be great to identify them, state the names to the parties and what their role is going to be and why they're there. So that is in the chair guides as well now. If you have a member who has been placed on probation and whatever sentence they had was kind of held out because they're just on probation, if they mess up within a year period, you can go back and put that keep them on probation or suspend them or re-invoke the punishment that would originally been meted out. So that was good. The next one is something, Article 4 of the Code of Ethics, and anybody who knows Article 4, it basically has to do with any ownership interest that you may have as an agent when you're buying or selling real estate. All right, so you have to disclose to the public. There was a case in a situation where a trust was selling a property and the realtor didn't disclose that her husband was the trustee. Right, and when we went back and looked at the Code of Ethics, that didn't have to be disclosed. So now it's actually going to include any entity. The language that the committee brought forward and took to the executive committee and onto the board of directors, the original language says, realtors who represent themselves, a member of their immediate family, their firm, or any entity in which the realtor has a legal interest or has a present or contemplated interest in the property for sale or lease, must disclose in writing the existence of such a relationship or interest to all parties to the transaction prior to any party signing any agreement. Okay, the executive committee actually thought the language was a little bit too legal and dumbed it down, if you will, slightly and made it like a laundry list. And if you've ever read the Code of Ethics, which most of you have, that's not the way it reads. So it really wasn't in keeping with the syntax and the way that the regular Code of Ethics is written. So when it came before the board of directors, we spoke up and said, hey, we'd like to refer that back to the professional standards, back to the interpretations and procedures advisory board to reword and send back to the board of directors for approval. And that was passed. But I just want to let you know that now it's going to include entities in which the interest and also any contemplated interest that may be there. The next thing was no member of the board of directors who referred a violation to grievance can serve on a tribunal that finalizes the decision. So if you've been on the grievance committee and you've actually sent that forward for a hearing as part of the grievance committee, you cannot serve on the board of directors that finalizes that decision. We cleaned up some words, and we also made sure that the chair determines the relevancy of any evidence or testimony. The board of directors can also remove an article if they find the findings of fact that are turned into them for approval do not match the violation. If it doesn't match, they can remove that article and take it off. In cases of interboard arbitration, panels now will consist of 5 members, and we determined how they're going to be selected as well. So clean that up a little bit. And then hearing panels can now go back more than 3 years or longer to consider a history of past violations. So if somebody has committed violations consistently over a long period of time, it used to read, hey, you can go back as many as 3 years. And now we're saying you can go back as many years as you need to and see if this person was a repeat offender on this particular article or has a history of violating the Code of Ethics in order to figure out what discipline you want to impose. So those were the 22 and 23 changes to the Realtor Code of Ethics in a nutshell. Byron.
Fantastic job, Todd. Thanks for your service. You've been active at the local board and the state association and the national association. For the realtors out there watching, I know you're good at business, but you're also involved with associations. What would you say to a realtor that's thinking, is it worth my time to get involved, the local, state, national? What would you say to that realtor?
I could say with great certainty that it's been instrumental in my career. I've been a top 1% agent my entire career, and part of that is, we're in the relationship business, Byron, and so I established relationships with other producers in the market through serving on committees and being involved and going to events. And when we're doing deals together, it's just easier, right? I know them, they know me, they trust me, I trust them. And so not only are you doing great work to make our realtor organization stronger and our business stronger, you're also developing lifelong relationships with people who now you're not only colleagues, but you're friends. So I've been able to do that at the local level and then serving at the state level and now at the national level. And it really does help you get things done.
Super. And you mentioned it, but I just want to reemphasize what a big deal it is. Todd's going to be on the National Association of Realtors. In 2024, he'll be the Vice Chair of Professional Standards Committee. And in 2025, he'll be the Chair of the National Association of Realtors Professional Standards Committee. Todd, kind of talk about your experience on the National Association of Professional Standards and what these positions will mean for South Carolina and realtors.
Sure. It's been really exciting. I guess I've been on National Professional Standards for about 6 years now, Byron. And we basically take the Code of Ethics and modify it based on things that happen. A lot of times people say, why are these things happening? Well, something's happened in a hearing or something's happened with procedure. And we look at it and say, all right, how can we make that better? How can we improve it? How can we clarify it? Because like I said before, the Realtor Code of Ethics is a living, breathing document, and it does need to be attended to. We can't just, it's been out there for 110 years now, right? Since 1913, if I remember correctly. So 110 years, and it's been constantly modified. And every year we look at different things that are key points and things that happen. And we have a whole bunch on our plate every single year. Whether it's something semantics and wordsmithing something, or whether it's a major change like we did when I first joined. My first thing was to make changes to the Fair Housing article, Article 10, right? And we brought in 10-5, and I know we'll talk about that later, but that was some pretty heavy lifting for the committee, and there were a lot of people who were passionate about making those changes,
What are some of your goals for next year? Do you have any agenda items or anything you really want to get past?
I'm committed to making the code better, right? And to make it apply and to having agents enforce the code. I think enforcement is the main thing. One of the things that I'd like to see is, we meet twice a year as a professional standards committee. I would like to see more discussions on the hub where we can communicate about the issues that we're going to be seeing in May at the first meeting and then in November at the second meeting, because we have 100 people on this committee, and some of the smartest agents that I know in the country are on this committee. And I'd like to use all of that brain power to make it better. So I'd like to see a little bit of a procedural change, as well as, there's some ideas that I have for the Code of Ethics to improve it as well. So They typically come to us, and I think we as agents need to come to them and say, here's some things that we think need to be addressed. And I can tell you with great certainty that if that's brought to staff, that it gets to us on the committee and we address it. But yeah, I'm really excited about the opportunity. When I look at my involvement in the association at the local, state, and national level, the legal and ethical part of it has always been my thing. I mean, it's what separates us from real estate practitioners, right? Every time I do a buyer presentation or a listing presentation, I pull out the Code of Ethics and tell them how I'm different, right? And I think it sets us apart. And I'd like agents to start telling that story, especially in light of lawsuits and some of the things that are going on out there.
You mentioned Article 10-5, which is the article that prohibits harassment speech based on our protected class categories. How was it when you were first getting, what was the climate around then, and what made this so important for you to want to be a part of getting these changes made to the Code of Ethics? Yeah,
great question, Tiara. We had a special meeting of the Professional Standards Committee. This is during a time where I believe the board of directors was receiving, the national board of directors, which I also serve on, was receiving so many complaints. And most of the complaints were not with regards to violations of Article 10, but there's something in the Code of Ethics arbitration manual that says that the Code of Ethics only applies inside a real estate transaction. So we were seeing hate speech against protected classes on social media, right? Everybody hides behind their keyboard warriors, right? And they hide behind their keyboard and they spew out all this hate. And we couldn't charge them with anything. But at the same time, I can tell you, we watched about an hour and a half of different videos that people had posted with hate speech and shooting off guns with their realtor pin on and then inviting people to their open house. And this was giving us a black eye as realtors, right? That's not who we are. And we said, we have to do something about this. So we called an emergency meeting of professional standards. We were all on Zoom from all over the country. And the outrage on the committee that this was happening in this day and age was overwhelming. You could see how passionate every member of the committee was. We decided that we're going to remove the prohibition that hate speech could only be dealt with inside a real estate transaction. And we're going to expand it to the lives because you're representing yourself and people know what you do out in public. And for you to do that, it really put a black eye on our whole profession. I was really proud of the committee, and I can tell you that I probably in my 25-year professional career never been more proud to be a realtor than that moment when the board of directors went. So it was awesome. It was a pretty moving moment for real estate and for the committee, and I was proud of the work we did. And now it's up to everyone out here listening to this to enforce it.
Yes, that's awesome. Thank you for that. And what some of the biggest pushback that I see that people have with Article 10-5 is they feel like it is a restriction on their free speech or that it's going too far. Did you guys consider that or think about that when making the choice?
Yeah, absolutely. And we had a lot of people speak up and talk to that. We had legal chime in. Basically, the consensus was that our organization is a trade organization. And we're all members of this trade organization. It's just like if you belong to a private club, there's rules, right? And you have to follow the rules, and this is one of the rules. If you want to be a realtor, you have to subscribe to the Code of Ethics and to ethical treatment of all people. And we thought it was inappropriate for people to lash out and spew epithets and hate speech towards members of the public that they were supposed to be protecting and serving. So you have free speech in your personal life, but there are repercussions that come with that free speech, right? And that was the thought of the committee and the association. Does that answer it?
Yeah,
there's repercussions. Good. You can say whatever you want, but you may be kicked out of the club.
Exactly. Just like if you're in a movie theater, you can't scream fire or something like that.
There are rules of conduct
yes.
To belong to our association, and these people were clearly putting something out to the public that was not good for anybody. It was not good for our image, and again, we don't want those people in our association if that's the way they feel, right?
Yes, exactly.
They're welcome to have a license and practice that way, but if they can't treat everybody fairly and equally, then we have a problem with them.
Yeah, that's a good segue. The other thing that comes up when Tiara's point, is if there was a complaint filed, it would be with a hearing panel of realtors. So it'd be reasonable that somebody's not going to be found in violation for saying Merry Christmas. We saw, and you saw it too on the hotline, we see horrific hate speech, slurs, just stuff that would shock your conscience. I think it was, but what I was saying is that there is a way, there's a safeguard for not slippery slope. The hearing panel's made of realtors, so they're going to use some judgment when they have these things. And talking about hearing panels, because you've been a chair a long time, you've been on hearing panels. What are some of your top tips for hearing panels, especially on Zoom, about decorum, things like that?
So, we've kind of made a switch to Zoom, which is way more convenient for most people. But I find it, sometimes it can get a little bit casual, Byron, and this is a serious event, right? There's a violation of the Code of Ethics or there's arbitration. I want people to show up dressed like they would for a hearing here at SCR, right? I think that's the first thing. I want them to address the parties as Realtor so-and-so, not to use familial names, not to use first names and things like that. You need to, as a chair, you have to have proper decorum, right? And so you can't let people spout out, everybody gets their turn. I think that process is one of the most important things, due process, right? So everybody needs their time to speak, everybody has to cross-examine, everybody gets to make an opening statement, a final statement. It needs to be consistent, right? Everybody needs to be treated the same, and that's why we have a script as chairs, right? And that's why, I don't deviate, you've seen me, I don't deviate much from the script, right? If somebody gets out of hand, you're going to say, hey, we can't do that. It'll be your time to ask questions or provide testimony later. So, I think getting everybody calm, and making sure that the panel is professionally dressed, ready, has read all the materials before they get there, understands that we're not trying to decide if this was a bad deal or a good deal. We're trying to decide if there was a violation of the Code of Ethics, right? Or we're trying to decide who gets the money. It's a daunting task. It's one that a lot of realtors don't want because you basically have to stand in judgment of your peers. And sometimes it's very difficult, but I can tell you from serving on hearing panels for 20 plus years that I've learned a lot about what to do and what not to do. And you probably will agree with me, 90+% of the things could have been solved with better communication and these sorts of things, right? Better processes, if people had thought about it a little bit more. Most of them are not intentional, right? Most of the violations of the code, they didn't say, I'm intentionally going to violate the code because I don't care. Sometimes it's training, right? Brokers in charge can help with that. That's why we have triannual ethics mandatory, right? So for all realtors to do it every 3 years. And it used to be every 2 years. I wish it was still every 2 years. Shoot, I'd probably go for every year, You can't hear about the Code of Ethics enough, in my opinion.
Yeah, definitely. That's a good point, because that kind of opened my eyes. What you were saying was you almost kind of put yourselves in the shoes of the respondent. You want them to feel like they got treated fairly, they got treated professionally, but when they walk out of there, the goal is not to discipline them, it's to lift them up, right, to educate
Absolutely.
them. Right?
Yeah, you'll see, I rarely, and I have given fines over the years, but typically you want it to be a learning experience, right? That was an unintentional breach. Give them a little bit of education, for whatever the subject might have been, and maybe a letter of reprimand, like, hey, you can't do that. And I don't think in 25 years I've ever seen anybody come in front of me twice. So, I think that people learn. You don't see a lot of repeat offenders, and again, unintentional, make it a learning experience for them.
Sometimes we get members of the public who call about our process and our grievance panel and those type of things, and they feel like if someone in our membership does do something against the Code of Ethics, that we're going to protect them from, being prosecuted for that violation, kind of like, oh, y'all are just going to let them get away with it, basically. And I explained that's not the whole purpose of the whole system. It's actually to weed out, bad actors, or to educate people to bring them up to a certain standard, not necessarily to protect someone who's done something wrong. I think that's a misconception that some members of the public may have, that we're not actually, going through this whole
No, I agree with you, and I've meted out a lot of punishment on committees over the years. Just because, again, we need to hold ourselves to a higher standard. For me, the Code of Ethics is an absolute minimum standard, right? It's the minimum standard for real estate. So, I aspire to something even more than that, right? So, we want to make sure that these people understand that if they did something wrong, there's repercussions to that, and we're going to hold them accountable. And again, that's something they should be telling the public as they present themselves for representation, saying, "Hey, I'm a realtor, and as such, I've subscribed to a code of ethics. Here's what that means, and here's what that means. If there's a problem, you have recourse." And again, I would rather them sit in front of somebody who understands real estate to be judged than somebody who doesn't, right?
Right.
Because we know, what should have been done, and you mentioned a good thing for chairs and panels not to do is not to preach to the people and say, well, why do you do it? In my office, we do it this way. Never do that, right? So, and I've actually seen it happen, and I've said, no, we don't go there. I'm going to stop them right away.
Yeah, those great tips for the chairs and the panel. Kind of the meat and potato today, though, one of the reasons we brought you in here, because A, you're a good speaker, well qualified. We wanted to kind of promote mediation. We're seeing our hearings and complaints go up, arbitrations over money, ethics disputes. What are some the pros of mediation and ombudsman? What do you say when they're saying, why should I get involved with mediation or ombudsman as a...
Sure. Yeah, so the two processes, as you know, are a little bit different. Ombudsman is a little bit more casual, right? So I'm going to reach out to Tiara, and I'm going to speak with her about the issue, and then I'm going to talk to you about the issue, and then I'm going to see if I can find some middle ground, right? And mediation is going to be, we're probably on Zoom, and we've got a set time, and it's not back and forth. Ombudsman could occur. I've had 2 weeks to solve one before. And you just keep going back and forth until the parties agree. But in terms of the benefit of it, if you're talking about an arbitration over money, the two parties get to decide what the outcome is going to be, which I really like. So when I'm hearing an arbitration as a panel member or as a chair, at the end of it, I'm going to decide who is the procuring cause of that sale. And that person is getting 100% of the money. And the truth is, I've rarely seen a case where the person deserved 100% of the money. The other party had probably done a lot of work as well, but whoever the procuring cause is, based on a number of factors, is going to get all the money. Well, in arbitration, each party gets to decide, hey, what was my part worth? And also it helps preserve business relationships. If I have to do a deal with you later and I've taken you to arbitration and gotten all the money, you're probably not going to want to work with me again, right? And it's going to be a detriment to my client. Plus it's quicker, right? I do mediation. I get all that weight off of my shoulders, and we solve the problem, right? Realtors, by their very nature, are problem solvers. That's what we do. We solve everybody else's problems. We should be able to solve our own. So I really like arbitration. In fact, I've been a mediator for 17 years, maybe going into 18 years now. And I've successfully mediated every case. And I say the parties have said, I've led them down the path to success, right? Because you're just opening up the line of communication. As we spoke earlier, Tiara and I were talking, I think that one of the big things is you got to get them past the anger. They're angry, they want all the money, they think that you did something wrong. And a lot of times when you get them in a mediation and they hear the other side's story and they go, man, I don't like my chances as much as I did before. Maybe we should just go ahead and solve this and get it behind us. So mediation is a fantastic process. It's also great for ethics, right? So I really like citation. I really like mediation for ethics. Any way that we can solve this without having to bring in other people and let the parties solve it and come to a resolution. I did an ombudsman for somebody at one time, and basically there were some things that were thrown out of their house. They told the realtor to take care of some stuff. Well, the realtor threw away their favorite chair. And it just came back to, hey, give me like a little bit of money for that favorite chair, and I'll drop the charges for this ethics violation. And the realtor said, oh, I'd be happy to do that. So instead of having to go through the whole process, the member of the public got what they want, and the realtor didn't have to face up. The other thing that's great about either arbitration, mediation, or ethics mediation is that every option is on the table. if somebody comes to you as legal staff and says, well, and you say, well, what's your end game? What do you want? And they want money. We can't give them money as a hearing panel. But the realtor can decide, yeah, that's best for me. Let me go ahead and do that. So all the options are on the table. There's a plethora of options versus very limited options for a hearing panel. So I really think it's a great process. Back in 2017 or 18, maybe 18, was I legal and ethical chair then, maybe 19. I came to the board of directors and said, we have the option of having mandatory mediation before arbitration. And I know that's cut down somewhat on the amount of cases that we have to hear on arbitration panels. So that's been instrumental. And again, realtors are problem solvers. It's not unreasonable to think they should be able to solve these problems themselves without having to go and have somebody else do it. Because if they want somebody to decide, I'll decide for them. They might not like the decision.
That's a good point, because a lot of people think, oh, mediators, there's some lawyer or some removed, but they're realtors. There are other realtors that are trained. Todd's thinking about going to the NAR mediator school in the future. He's been to our state training, he's been to local training. So if you're interested in being a mediator, sign up for one of these classes. And I like what you said, it's quicker. If it's money involved, both sides it's win-win is one way I talk about it.
It really is. It really is. And that's, as a mediator, people misconstrue what we do. We lead the discussion between the parties so they can come to their own decision about how they want to resolve the situation. We don't make a decision. I don't say, hey, here's the answer. I say, what do you want? What do you want? And we go back and forth. And I've had mediations that were 8-9 hours, and then but I use some scripts and things that cut mine down considerably after that one. I basically tell people if I find that if the parties are reasonable and both reasonable and intelligent, this shouldn't take longer than 2 hours for us to get it resolved. And I do like this, and I wait until their head bobs until I stop with mine, and I just keep going. And once they do this, I know it's just a matter of time. So, but I think everybody thinks they're reasonable. And they think they're intelligent, and so they need to prove it to me.
Yeah, and you could even get an apology. A lot of times, member public say, "I just want him to say I'm sorry." In
Sure.
the hearing, you don't get that, but
No.
with the mediation, you could.
Exactly.
And I'm kind of springing something on Tiara and Todd. Did you have questions on anything we've covered here before I surprise you guys?
What about confidentiality throughout this process? What if I'm sitting on a panel, but I know the respondent or the complainant? Can I continue to be a part of that panel?
Yeah, you can. You just can't disseminate any information, afterwards. And you can't if you don't think you can be impartial, you need to remove yourself, right? So, as an association, you typically vet the people. They're also vetted through the complainant and respondent and said, do you object to any of these people? So if they had a problem with you, they would remove you. They would say, nope, you can't have Tiara. We've had a bad deal before, and I think she couldn't do well. Yeah, I've sat on, I was on the local board professional standards for about 20 years. And of course, I had to sit on a lot of grievance committees and a lot of professional standards against people I knew, right? And so we had to judge them, but they respected me enough and knew that I was going to I was just going to base it not on our relationship, but based on the information, right? So I don't read anything into it. You present what you have, and then we look at it and we make a decision, peer judgment based on, what we think should happen.
Super. Yeah, and I'm kind of throwing a curveball to y'all. On the hotline, earnest money disputes is a pretty common thing. And this will be an abbreviated mock mediation, but you'll kind of see how Todd works as the mediator. So Todd, you can be the mediator. We've got your cheat sheet there. It's a failed deal, $1,000 earnest money. I'm the seller. Tiara is the buyer in the failed deal. We're disputing $1,000 earnest money. We each accuse each other of breaching the contract. And we each kind of, we've got our little notes here, but kind of, if you were starting with us, we're at a table and you're going to mediate $1,000 earnest money. How kind of do an abbreviated version of that?
Yeah, sure. So you want to let people know that you're happy that they're here, that they're willing to solve the problem, right? And then you're going to give them their alternatives if they're not able to do it, right? Because I think people they need to know that this is the best alternative is to solve it themselves without having to go through and that sort of thing. Because if you can't decide on it, it's probably going to go to court. and then you're going to hire a lawyer and you're going to be tied up in court, and what legal fees are going to be involved at, I'm not sure what you guys charge anymore, but I'm sure it's pretty, there's been inflation, right? So the legal fees are going to be a little more expensive. So I'm going to kind of go over your alternatives if we can't get this solved today or this, right? And then, I'm going to let them talk about the problem, but only for 5 minutes each, right? Because we're not here, and then I'm going to make the statement, we're not here to talk about the problem, we're here to talk about the solution. So if I catch either of you talking about the problem again, I'm going to say, no, we can't do that. We're only going to talk about the solution. I'm going to tell them that, that I found that intelligent and reasonable people can usually solve this, and in an earnest money dispute of this size, it shouldn't take more than an hour. Do you have an hour that we can go ahead and solve this?
Yes.
And I'll do like this, and I'll wait for them to shake their heads, and I'll say, Byron, tell me about the situation, and you'll tell me, and because she may not know how you feel and what your point of view is, right? So she's hearing you and go, oh, man, I see why I would feel that way. And then I'll say, well, Tiara, tell me about how you feel. And then all of a sudden, boom, boom, boom. By the way, it's never about feelings, it's always about facts, right? In any case, right? So it doesn't really matter. But I got to get past the anger in order to get to a resolution. And then I'll say, well, it looks like we have $1,000 in dispute. Tiara, what would you be willing to do to make this go away today? So you could get all this hatred out of your heart, be finished up, and move on with your life. What is that worth to you today?
You can almost take us separately, right? And it's almost like making a deal, right?
Yeah. So I'll once we talk and you both tell your sides, I'll separate the two of you, right? And we're doing a lot of these on Zoom now. I've done them in person for years, but we're doing a lot of them on Zoom at this point. So we'll just put them in a different room and we'll talk this way, and you'll say, and what's your answer? What would you be willing to do today?
Well, my problem is I felt that they didn't disclose something, so I didn't want to go forward with purchasing the house, and I think I'm entitled to the earnest money based on that. But, at this point, I've already purchased the home, and I need to get my HVAC system fixed. So, I'm not really trying to get a lot of court costs and things like that. But I also don't want to just lose my whole $1,000.
Sure. Yeah, I understand that. What would you say would be fair? What do you think would be fair? A lot of times you want to see where fairness is, right? Because there may be a zone of possible agreement, a ZOPA, if you will. Anybody who went to Harvard Law School and studied negotiation, which I did, which is kind of cool. I'm not a lawyer, by the way, so I just studied negotiation and I teach it. But there's got to be this zone of possible agreement where you're willing to do this much and Byron's willing to do this much, and where it overlaps is where we're going to find the common ground where we can get it done, right?
Right. Well,
So I need a number. If we're talking about money, you got to get to a number, right?
Yeah, I certainly wouldn't want to split it in half. I would want to make a little bit more than half of the money, but still be reasonable.
Okay. What would you say? Would $600?
Yeah, actually, that's the number that was in my head.
Okay.
Yeah.
Great. So now I'm going to go back to Byron in his other Zoom room or whatever, and I'm going to say, Byron, I was talking to Tiara. She'd like to put this behind her. She's being very reasonable, by the way, right? So. Because you think she's unreasonable, so there's a third party who said, hey, she's being reasonable. She's willing to compromise in order to get this done, to put this behind him. Are you willing to compromise a little?
Yeah, listening to her, I thought she was in breach, but hearing some of her story, I realized what happened. Maybe I didn't understand it at the time. So I've already bought another house, and now I got 2 mortgages. So I'd be willing to settle for $300.
Okay. Great. She offered you $400.
I could live with that.
And she'll take $600 and we're done.
Wow.
So
you're good at this.
Yeah, I know. It's the parties are controlling the outcome at the end. And that's the thing to remember. You're just leading them down the path. Now, sometimes you maybe have to lead them a little harder to pull them, drag them a little bit. And there are a lot of techniques that you'll use in mediation that you'll learn in the training. By the way, some of the best training folks you can have, and when I was legal and ethical chair for the state, I really pushed mediation. If you remember, we brought Stephanie Walker in, we brought her again the next year, and we said, in Columbia, South Carolina, which is my market, for years we had 2 certified mediators, myself and Andy Walker, for it was 10 years. And so anything that was heard, Andy or I had to hear it. And so when I got that job, at the state, I was like, we have to have more certified mediators because they're problem solvers. They can help other agents. And not only can you help mediate deals, but it will help you with your girlfriend, it'll help you with your wife, it'll help you with your children, it'll help you with your dog, it'll help you with your cat. Well, not really the cat. The cats don't care. They got a little bit more attitude. But it will help you in life, right? It'll help you be better at bringing people together. It'll help you with your clients. I mean, we mediate things with our clients all the time, right? We have differences of opinion, and so I think it's really useful training. As you said, there's a 2-day, and I believe as incoming vice chair, they might send me. So
awesome.
yeah, I think we were having that conversation with Stephanie Walker. She said, I think they'll send you, and I've done the training, I believe, with Bruce Ite once, and then with Stephanie Walker twice over the last 17 years. But I'd like to I've heard the one in Chicago is fantastic and well worth it. Everybody I've talked to who's been. So if you can't do that one, do the SCR one. It's a 1-day training, and there's a 1-day ombudsman as well. Both of them are fantastic.
Yeah, so when you bring us back together, so in this situation, $1,000 held by broker and charge, they're going to need a disbursement agreement. So some of the paperwork, you might use an agreement to mediate, right? You'd have us fill it out, sign that. You could also use like the SCR 518, the release, where we could release each other and disperse the earnest money.
Yeah,
so those
absolutely.
Are some ways to do that.
And folks, don't write up these things yourself unless you're having a law degree. I call SCR every time I mediate something, and I say, here's the intent of the parties, and we put it on the sheet, and we send it back to everybody, and they sign it, and and you can let the parties write it, but you can't do it yourself. Am I correct?
Good point. Yeah, and that's an excellent segue. You got to take a break. We made you talk a lot, but you can kind of take a break for a minute. We always do a top 10 hotline, so we're getting ready to do that. Thanks to our CFO, Alan, who compiles our member reports monthly. He's tracking complaints, and hearings are going up. So that's one reason we brought Todd in here, because we think ombudsman can help solve some of our ethics complaints without a hearing. And of course, when he was chair, he got that mandatory mediation attempt to help solve some arbitrations without hearings. But here's our top 10s for October. Number 10, earnest money. You just heard we did a mock mediation on that. Number 9 was a tie between property management and state laws. Number 8 was MLS issues. Number 7 is disclosure issues. Reminder to use SCR 230, the seller disclosure, to help protect you on disclosure issues. Number 6 was compensation, mediation, arbitration, which is another reason we brought you in today, Todd. Number 5 is due diligence. Number 4, ethics and professionalism, which dovetails right in with our mediation ombudsman talk. 3 is advertising. 2 is license law questions, and usually number 1 is always forms. So forms was our top hotline. Some things that came up on the hotline under the other subject. Other was number 3, I think. But do not call. Make sure you check in your federal do not call registries and your broker do not call registries before you make that call on those leads, because there are laws against calling and soliciting people on the phone if they've registered their phone with those registries. Also, kind of hand in glove with that, email marketing to leads. Make sure you're following what they call the Can-Spam Act, which means you have to say this is a commercial solicitation email, offer a free way to opt out of receiving those emails, and then honor those opt-out requests. And let's see, so some other things we're talking about. Todd, we can bring you back in on this one. So exclusive right to sell. Everybody's been watching the lawsuits out in the Midwest and now in South Carolina and other states, New York and Texas. Kind of, what's your number 1 tip with it? Say I'm the seller and you're going to list my house. How do you explain to me that all compensation is negotiable, and why is it my interest of a seller to offer a co-op to somebody?
Sure. Yeah. So basically, I'm going to say, here is my listing fee for your home, and here's what I'm going to do for that fee, Byron. All right. So if you hire me and you pay me my listing fee, you have one agent trying to sell your home, right? There's a lot of buyers, agents out there who are working with buyers who have compensation agreements with their buyers that will show your house if I agree to compensate them. Let me tell you, we can compensate. Here's my fee, and my fee, is negotiable. I'll take more, right? But let's talk about a fee for them that would get you the most showings, which would net you the most money. All right, so, and I'll ask them, I'll say, do you think a lower fee would bring more interest in your home to the buyer's agents? They say no. So what about what about a fee that's somewhat close to the middle? They go, yeah, that'd probably be okay. I said, what about a higher fee? Would that get you more showings and potentially more offers and potentially net more money? And they said, yeah. And I said, well, let's talk about what that would look like. And, I'm not going to talk about, percentages because it could be look like antitrust. But, I basically want to show them their options and that offering a co-broke fee is a good idea because it's going to get their house 5,000 people instead of one trying to sell it. And then setting that fee at something that is going to attract the most agents with the most buyers is up to them, right? So we're going to talk about where that is.
Super. And then like in our mock mediation tier with the buyer, so say you're going to sign her up as a buyer client, buyer agency agreement, what's kind of your top tip to buyer agents about explaining their value and negotiable? Compensation is always negotiable for them.
Yeah. So, for me, and I think we're going to have to change the conversations that have been had over the last 25 years. I've done it the same way for 25 years, and I've always explained my value proposition. Here's what I'm going to do. Here's what I'm going to charge you. Now, there could be a situation, Tiara, where I'm being offered compensation that will offset what you've committed to me. And in that case, you would not be having to pay me because the seller is offering compensation through a co-broke arrangement. I explain how that works. But there's a great thing on competition.realtor. I think it's the 105 things that a buyer's agent does for you. I think that's instrumental to having a buyer presentation. I find that about 95% of agents do not have a buyer presentation. They have a listing presentation, but they have no idea how to show their value to buyers. So that should be something that should be included in your your buyer presentation. I always do a buyer counseling. I don't meet anybody at the property. I don't meet them at the house. I have them come in a place of business where we can talk about setting up a relationship where I can represent and protect them and help them, right? And seeing if we're a good fit. It's two-way communication. I'm showing my value, but I want to make sure that they are sincere and able, to purchase a home. And then, if they are, then I'll be willing to help them. So, you're always going to explain what you do, what it's going to potentially cost them. And then there is the potential that compensation that they would owe you is offset. But those are things you have to have up front, not when you find a house.
So would you ever show someone maybe like 20 homes without getting a buyer agency signed? And then maybe the 21st home you weren't available, so they went and saw it with another agent?
I've heard of agents doing this, but I've never done it. In fact, I've never put anybody in my car without a buyer agency agreement.
And why is that?
One, I'm very uncomfortable in what would have been sub-agency in the past, where I was basically a sub-agent for the seller when I walked in their home with a buyer who I wasn't representing. Two, in the past in South Carolina, it's not the case anymore. So this is my thought process, right? If you had to have a buyer or a seller, a client in the transaction in order to receive a commission in the state of South Carolina for many, many, many years. So I was like, well, if I don't represent you, who am I representing? Mm-hmm. If you don't trust me enough to hire me and I don't trust you enough to work with you, then why should we be going out and dancing? So I don't put people in my car without one. I basically use a script to kind of guide them through, and you better have showed your value proposition before you do what I'm about to say, right? But I'm going through the 105 things that I'm doing for them, and then I say, Tiara, have you ever been in a relationship? And what does everybody say every time? Yes. How does it work when one party or the other is not 100% committed? How does it turn out?
It's going to end.
And not well,
yeah.
Right? That's been my experience as well. Well, today I'm willing to commit 100% of my effort, time, and knowledge to helping you accomplish your real estate goals. But in return, I expect 100% commitment from you. Is that fair?
Yes, that's fair.
So we've had the compensation about my value, and I'm saying I'm going to do what you need me to do, and I'm going to be there for you, and 100% of my devotion is to you, but I expect the same thing. And I think once you've showed your value, you can have that conversation. And every single time for 25 years, they said, where do I sign? So, but they understood what I was bringing to the table. And then I said, look, again, I'm taking time away from my family, my friends, what I want to do to help you accomplish your goals. But in return, we have to be loyal to each other.
You made a good point about bringing them into the office, kind of realtor safety led into another one of our member benefits is the Forewarn app. It's a way to look up people by their phone number or their name, get an instant background check. It's part of your overall safety protocols. It's not 100% guaranteed to stop bad actors, but bringing them into the office is a way to deter them, collecting information about them so they know, hey, somebody saw me with Todd. If I go out to the showing and try to rob him or kidnap him, somebody's going to find me. So it's kind of a deterrence thing. And Tiara, you want to give your spiel about how to use 401, please?
Yes, you want to use it ethically. You only want to use it in reference to your real estate transactions. Let's say you're about to take someone to go see houses, or you're about to get ready for a listing agreement meeting or something like that. You wouldn't want to use it outside of the scope of those things to look up friends or family members or people that you're dating. You want to stay within the scope of the use and the terms of agreement. But we have been seeing great results with safety and helping with land scams lately, which is a thing that's on the rise. You can actually check to see if someone owns the property. Of course, it's not 100%, but typically if you actually own the property, your name is going to show up as the owner, or as your previous address if you sold the property or something like that. So it has been really helping, and it's also been helping with certain safety concerns, like buyers who they only want to meet at random locations that are away from everyone. They don't want to come to the office, things like that. For your safety, you may want to just double check that on forewarn and make sure that everything is up to par. And if something ever feels strange or feels off, most likely it is, and give us a call and we can walk you through that, because a lot of these situations are the same thing, just different locations and different agents are involved, but it's kind of the same stories as far as scams.
Super. And then Todd, this is the part of the show where we do Is It Legal? It's a game show. Tiara's very familiar with it. So Tiara, I'll ask you the first question. Is it legal? The amount of compensation in the listing broker agreement or the buyer agency agreement, is it negotiable?
Yes, it's always negotiable, and it's no set standard that everyone has to use. This is negotiated based on, as Todd was saying, your value proposition, what you can provide to that seller, what you can provide to the buyer. And you want to be able to show those things for either side of the transaction.
That's correct. All right, and then Todd, is it legal? Can the mediator or the ombudsperson later sit on the hearing panel in ethics or arbitration, or the board of directors that are ratifying the decision, or even the appeal hearing?
No, they cannot, Byron.
That's correct. Tiara, is it legal? You must check do not call registries, both federal and your brokerage. Do not call registries before cold calling leads.
Yes, you always want to do this because you could be in violation if you do call someone that is actually on those do not call lists.
Correct. Todd, is it legal? Is a mediation attempt required prior to a South Carolina Association Realtor arbitration hearing on money commission disputes?
Absolutely. I brought that to the board of directors when I was legal and ethical chair, so I think it was a great change.
Correct.
2 Ds.
All right, and then Tiara, any questions? I'm going to kind of wrap it up with some of our advertisements, but if you have any more on your list.
No, I don't, and I just thank you for this, and I think it would be good for us to do another one of these, maybe talking more about that value proposition and how to have those conversations, because maybe you've, of course, been doing this for a while, but maybe someone who hasn't ever had that conversation about the value they bring as a buyer agent, I think it's important that we start doing some training or just podcasts or just things to educate people on how to have those conversations, how to show that proposition and value to our clients.
I agree. I'm actually, here's a little commercial for us. I'm an ABR instructor, I'm an NAR instructor, but I teach the accredited buyer's representative. I actually helped write that program, rewrite that program with NAR. And we're doing one at CCRA here in Columbia, which is open to all SCR members, as you know. We don't just make it for CCRA. But I'm going to be teaching the ABR on April 9th and 10th, coming up in 2024. And I think given the climate with the law change, with the lawsuits and things, I'm going to take a couple of different tacks and really concentrate and drill down on some of these things that have been problematic and help people with their overall buyer business.
Super. And part of our advertisement, Tiara, you want to talk about the license plate and the grant program you're working on now?
This is our South Carolina American Dream home ownership license plate, and you can purchase one of these, and your contribution for purchasing this will go towards a fund where we support local habitats who are doing new builds on affordable housing. And each year we allow any habitats to apply in the state, and then the money that is in the fund from purchases of this license plate, we just divide it equally between the applicants, so everyone gets a equal number, and then they use it towards the projects that they're already working on or things that they will be working on in 2024. So we encourage you all to buy the license plate because it helps build up that fund.
Super. And then Todd's talked about the lawsuits. Nick Kromitis, CEO Nick Kromitis, the legal team, Tiara, Austin, and myself, we can come to your board, we can come to your office, we can do Zoom, we can do updates, legal updates on that, and a variety of things, mediation, ombudsman, or even the lawsuits. For 2024, for association executives, you've got new incoming board of directors, you've got new chairs and vice chairs. The South Carolina Association of Realtors legal team can do Zoom or live training on board responsibilities, talking about things like how you're insured as a volunteer, how you have immunity as a volunteer if you do what you're supposed to do by reading the information, relying on accountants and lawyers that are giving professional advice to the board, and that the board can indemnify you. And that's all to get you to volunteer, so you're not out there getting your house, getting a lien put against it. It's to encourage volunteers. We can talk about Robert's Rules of Order, talk about issues like social media, employment issues, which is a high risk when you're serving on board of directors for an MLS or an association, harassment issues. You heard us talking about 10-5, alcohol, drugs, mental crime, things like that we can cover with your board of directors. Thanks, Mike Christ. He's doing the producing, the editing, and directing today. Sharon Stone for the marketing. Shantae Alban, the Hotline CSR up front. Thanks to Lindsay Pittman, our Professional Standards Administrator. Thank you, Todd, for coming in. Remember, we got our awards gala for South Carolina Association of Realtors December 14th. Capital Conference 2024 is coming up quick, Todd. January 31st will be our Capital Conference here in Columbia. And in closing, any last words from you, Todd?
No, I appreciate the opportunity to come in and speak. I would encourage everybody to volunteer, to get out there to serve at your local level, at the state level, and at the national level. I think you'll get a lot out of it.
Super. Tiara, any last words?
Well, thank you guys, and I look forward to continuing conversations like these, and thank you so much for being here.
My pleasure.
Yeah, and this is our December podcast. So in closing, Merry Christmas, Happy New Year 2024, Happy Holidays, Hanukkah, Kwanzaa, and others. Realtors, keep it safe, legal, and profitable. We'll see you next time on the podcast. Thank you.